Yes.
Welcome back to another edition of Between Two FARS. I'm Warnike Miller, and I'm here once again with Michael Mark. And today we are talking about administration of rights and inventions. Now, this is an area that I am not familiar with at all, but Michael has been doing this type of work for a very long time. In fact, one of his earliest jobs was doing patent work for the Department of Defense. And he has got over 40 years of experience now. And we really do want him to bring that wealth of experience to the table to help us as line attorneys have a basic understanding of these rights and the administration of these rights, because you just never know when you might be called upon to take a look at some of these reporting requirements. So let's just sort of get started with a general concept of rights and inventions. How would you give a primer to somebody who's new to this area?
Well, like everything else, our research and development contracts cover this subject, and there is a clause. The FAR clause is 52227-11, but NASA has an extensive supplement to that, and we'll talk about that in a minute. And it lays out the patent rights, the rights of each party. And essentially what we're talking about is rights in what the clause calls a subject invention, which is an invention made by the contractor in the performance of work under that contract. And what that means is one party is going to own the invention and the other party is going to have rights in the invention, a license to use that invention. Now, typically under FAR contracts, the ownership stays with the contractor and the government takes a license. But NASA is one of the two taking agencies in the federal government, the Department of Energy being the other one. And what that says is that particularly for large businesses, if a contractor comes up with an invention under a contract, NASA owns that invention. Now, NASA also has a waiver process, and my experience, and I'm not a patent lawyer and I'm not the patent counsel here at Langley, but my experience has been that the vast majority of times we will waive our rights and just take a license. So that means, again, the contractor has the right to elect title and file in those cases. With small businesses under the Bayh-Dole Act says the small business has the right to elect title. So we have a clause that covers that as well. If the contractor elects title, then they file and we take a license. If they elect not to file and we think it's something worth filing on because we think it can be licensed, then we will file the invention and they will get a license. So basically that's the outline of what the clause requires with the terms of who owns what. And the way we understand what's going on is it has reporting requirements. So every year, the contractor is supposed to file a new technology report. And that report goes to the new technology representative. And what you're seeing right now is the NPR 7500.2, which deals with new technology and technology transfer. And it defines what a patent what a new technology representative is and what a patent representative is. And basically the new tech rep is the person who administers the data gathering under that clause. They're usually in the tech transfer office here at Langley, that's where they are. And so they are the ones who coordinate with the Corps, and the Corps, remember, are contracting officer technical representatives, so they have some technical knowledge of the work that's being done. And they're supposed to confirm that the reports are accurate and send that to the new tech representative. At the end of the contract, there is a final report that rolls everything up. And again, the Corps and the new tech rep are supposed to verify that it's accurate. And then it goes to the patent representative, which is under this regulation, the patent counsel at each center for final review and approval. So the patent counsel is supposed to sign off on this and say, yes, everything's been reported, it's accurate, we don't have any issues. Contracting officer, you can make final payment under the contract now. Every so often though, and this is why you need to pay attention to these things, we discover that not everything has been reported. For instance, the Corps may say, I've looked at their technical report and it's describing an invention, but I don't see it in the new tech report. So
what
we'll go back to
options do they have at that point?
Well, since the contract is still open, we can ask them to amend that new tech report. And we often get into discussions with them. We think it's something you need to report. They may say, we don't think it's a subject invention, and we'll argue about that. and reach a resolution, or they may say, we don't think it's an invention. And every so often they say, you're right, we forgot, we'll add it in. And so normally that's not a problem. But in 2 instances here at Langley in my time, the way we found out was when we checked with the patent office and discovered that there was a patent application there that did not indicate that the government had rights in the invention. One of the provisions in these clauses is that if the contractor files, they have to have a statement in there saying that the government has rights in this invention under contract umpty-ump. And those 2 contractors didn't do that. And there is case law out there that says the government then has the right to require the contractor to forfeit the invention to the government. And that's what we did in both of those cases. So there is a severe consequence to the contractor if they deliberately fail to report the invention. It's not unusual for them to forget to report, or they make a judgment they don't think it's a reportable thing. It's better for them to talk to us rather than for us to be hectoring them, so to speak. Oh. But those, remember, a lot of these are small businesses. They're not, real disciplined in that way. They're mostly concentrating on the work that they're doing, and they're not always paying attention to the administration issues. And that's why the new tech representative and the cores are so important in the administration of these provisions, because these are very valuable technologies. We have, at Langley, we have multiple millions of dollars worth of licenses going on right now. And inventors get a portion of the revenues that we get under those licenses. So if a NASA inventor has invented something, NASA takes title to that invention, but if it's licensed, a portion of those royalty payments go back to the inventor. And some of the inventors, I must say, are doing very well that way because they have multiple inventions with multiple licenses, and they get a portion of those royalties.
And it looks like, in addition to some of the other hammers that you were talking about that we have for compliance, the contracting officer down here is not going to approve release of final payment till we have all of this straightened out?
That is correct. There's a whole string of things that have to be done before final payment is allowed, and this is one of them. We have to make sure all the reports are in, that all of the final clearances have been received, that the patent rights have all been adjudicated and taken care of. And until that happens, we have the ability to withhold final payment, or at least a portion of payment. If there were progress payments, we would be withholding progress payments, but NASA doesn't do that very often. We don't use progress payments. So at the end of the contract, as part of the clearance process, this is one of the gates that has to be done, and it will run through the legal office. And when I was in the Air Force, I did this in my first assignment. I was the patents officer. No, I'm not a patent attorney. And I pointed that out to my management when I got there, and they said, oh, you don't have to be because you're just administering. But I had to rely on the cores and on the technical people to make sure that everything was being done properly. And every so often it wasn't. And we had to go back and deal with that.
Yeah, what would the attorney be looking at when they see this final report coming in, especially if they don't know a whole lot about the underlying technology? What sort of, is there a specific language they should be looking for, or are they solely relying on their technical points of contact to understand if something's been overlooked or omitted off this report?
Well, they won't know because they won't have seen all of the other paper that's associated. So they need to, if they're not sure, they say, can I see like the final technical report? And the final technical reports, if we're going to load them into our STE system, they have to receive review. And in our office, that's done by our intellectual property law team. They're all patent attorneys. And that is a large chunk of their time, is going through these things. And that's one way we often find out that we think there's an invention. The other thing is the report is what you're getting is a form. So it's supposed to list the inventions and whether they've elected title or not, and if they filed, that what the application information is. We typically get a power of attorney so that we can see the patent application if it's still under seal. So what the lawyer is looking for is the report complete? That is, it looks like it's got everything listed, every data point has been filled out. Has the Corps looked at it? Has the new technology representative looked at it? Have they signed off on it? Do they have comments? Those are the kinds of things that I would be looking for. And if I'm not sure, then I would go back and talk to them and say, okay, I'm new to this. I'm not sure I'm following it. Walk me through it. Let's make sure we've got everything we need here. Most of this is done through the patent attorneys. So like right now, I don't see these final reports unless we get into a big argument. And that has not happened very often, I must say. But so I rely on people like Robin Edwards and her team to tell me when they think they've got a problem and that we need to interface on that. That's another reason why talking in your office is so important, because they're doing things that you don't typically deal with, and you're doing things that they don't typically deal with, but they intersect, and we both need to know what the other person is doing. That's
and
really important.
Serve as the role of the translator, huh?
Absolutely,
Building
absolutely.
bridges. Well, thank you so much. This has been a great overview on these patent reports and an area of the law that we're not likely to practice frequently, but as procurement attorneys, you may find yourself in the middle of a big situation, and having this background is going to be incredibly helpful to get you up to speed quickly so that you can jump into the fray and be real helpful to those patent attorneys and Corps and contracting officers working the issue. Thank you so much for your time today. And y'all join us here again next time for the next edition of Between Two FARS.